Right. It started already now. Right. So yes, I welcome you all to the inaugural event for Center for Constitutional Law, Dharmashastra National Law University, Jabalpur. Held on a very relevant topic of 48 years of basic structure. It is today on 24th April 1973 when our Supreme Court of India delivered a historic opinion in the case of Keshananda Bharati and gave us a set of accountability measures which we call as basic structure. In today's time and era, when we are seeing the sudden rise of populism across regional and international level, it becomes our responsibility as a part of legal fraternity to awaken or rather invoke the spirit of constitutionalism through the means of basic structure. It will not be wrong to say lurking behind a great constitution and basic structure is the spirit of constitutionalism. And it is this spirit of constitutionalism which we want to awake. In pursuance of this goal, we have organized this August e-gathering consisting of some of the most brilliant legal minds in the world. Let me introduce them to you. First is Professor Dr. Krishna Mahajan. The suffix sir attached with the name of Krishna Mahajan sir comes out of the sheer respect which we all have for you, sir. He is one of the most respected and admired legal academicians across India. As a scholar, he has done his master's from Columbia Law School, America. He is also a senior advocate in Supreme Court of India and was also appointed by Supreme Court as an amicus curiae in the case of Kanpur Tannery case and Taj Corridor case. He has also worked as a legal journalist for several national newspapers, such as the Hindustan Times, the Indian Express, and the Times of India. As a legal scholar, he has also produced a magnum opus book titled Legally Victimizing National Monuments, the Role of Parliament, Union Government, and Supreme Court. We await to be enlightened by you, sir, and we are thankful to you for taking out time for this session. The sixth,
Thank you, Ashit.
yes, sir.
Would you like to introduce all the others and then?
Yes, sir. Yes, sir.
Yeah, please do that.
Yes. Our second panelist is Professor Dr. Yogesh Pratap Singh, sir. Professor Dr. Yogesh Pratap Singh is a legal scholar par excellence. He is currently serving as the Registrar at National Law University, Odisha, where he's also served as the Interim Vice Chancellor. He has completed his master from the reputed National Law School of India, University, Bangalore. His thesis on contribution of dissenting opinions of Indian Supreme Court judges to the Indian legal system, a critical evaluation is recognized as a significant contribution in the Indian legal system. His thesis was later published by Thomas Reuters as a book. Honorable Justice D.Y. Chandrachud has written the foreword for that book. And if you do not know about Yogesh Pratap Singh, sir, you probably are not reading the Indian Express, the Statesman, the Pioneer, Life Law, the Point, EPW. And if you have read that, you must be knowing about him already. The third panelist for our group of our session is Professor Dr. Yaniv Roznai, sir. Professor Yaniv Roznai is an associate professor of law at Radzyner School of Law, Israel. He has completed his PhD and his master's from the prestigious School of London School of Economics. Professor Yaniv has also holds a postdoctoral fellowship from Minerva Center for Rule of Law under extreme conditions, University of Haifa. His thesis on unconstitutional constitutional amendment, the limits of amending power, a landmark work on entrenched provision of the Constitution, was published by Oxford University Press. We are more than happy to have you, sir, in this August e-gathering, and we await to be enlightened by you, sir. With no further ado, I give the stage to my moderators, Ashutosh and Vandana. I think they can carry forward from here. Thank you.
Thank you, sir. And good evening to all the panelists. Thank you for your time that you have choose our webinar for giving free flow of education, because as you know, we know that we are living in the 21st century, and here the knowledge is power, and because of that we are here for the free flow of knowledge. So thank you to all of you, and thank you to all who have joined our session. So first I would like Sir Dr. Krishna Mahajan to enlighten us with his knowledge and with his experience in the field of law, and with respect to the constitutionalism and doctrine of basic structure in India. So.
Thank you, Jagtap. First of all, greetings to the Dharmashastra Law School, and greetings to all of you, the management, the staff, the teachers especially, and the students, of course. As you know, without students, there is no university. So it's as simple as that. The this basic structure doctrine has been one of the outstanding judicial illusions of India. It may not be wrong to call it a delusion. It came at an X point of time of a certain kind of politics. And if you read the judgments carefully, you will find that the judgment is almost a judgment written out of fear of what could happen in India. So therefore, the first question that arises is, does that political situation still continue? And if it continues, then what is it that the Supreme Court has done in terms of the basic structure doctrine? The Supreme Court, please look up this judgment. Russell Joy, it is a Meluperier dam case, has said that freedom from fear is a fundamental right and is the basis of life. That is Article 21. If you don't have freedom from fear, life is not worth living. So it is almost declaring, without using the words, that freedom from fear is part of the basic structure of the Constitution. Has the Supreme Court done anything for the people of India in 70 plus years to get them free of fear of elementary existence? Food, water, health, skills, employment. If the answers are no, then what is it that the Supreme Court has done? Because please remember that in Article 32 of the Constitution, the Supreme Court is not an institution for declaration of rights. For that, I could have filed a civil suit for declaration. I did not need a Supreme Court of India. It is for enforcement of rights. And what is it that it has done for enforcement? I am afraid this part of the story tells a very, very disappointing picture of the Supreme Court of India. Now has it been able to stop the basic structure doctrine, any politician in power, from doing what they wanted to do? From Mrs. Gandhi downwards, whether it's privy purses, whether it's bank nationalization, whether it's, treating a bill as a money bill. So the Supreme Court of India, as a matter of fact, has just sat back and quite often kept silent. This is an increasing posture of the Supreme Court, that something is happening before the whole nation, and the Supreme Court has to be prodded literally into action. That please take note of this suffering going on right across India and do something about it. That doesn't happen. So therefore, suffering as such, it does not attract the attention of the Supreme Court of India in terms of the basic structure. So what good is the basic structure? And mind you, after Bomai, basic structure applies to legislation also. So do I want a basic structure which applies to legislation of a bundle of laws that remain unimplemented for years together? For years together. You pick up any act of India, any act, Bonded Labor, Reserve Bank of India Act, you pick up Foreign Trade Development Act, you pick up any act of India, Commercial Courts Act, the rape law, the Anti-Dowry Act. Where is the implementation? So the Supreme Court is sitting on top of a bundle of laws which everybody knows have not been implemented, on which, as a matter of fact, there are official reports of non-implementation, and yet it says nothing about the basic structure. The basic structure, therefore, is a hollow thing. There is no point in my having legislation to which the basic structure applies, which actually was never meant to be implemented, has not been implemented. The laws are not implemented. And that is why I came to the Supreme Court. I said, look, Parliament has passed these laws. I am entitled not to suffer in the manner in which I am suffering, not to live in fear. Please implement this. Now, what is the point if the Supreme Court will not invoke the basic structure at all? So therefore, it's a delusion. It's a complete delusion. And plus, in the process, please remember the history, especially the current history, of the evolution of the judiciary, especially the Supreme Court of India. I've been writing long ago on this several times. How does one become a judge of the High Court or Supreme Court? Is anyone willing to speak the truth about it? Does no lawyer will stand up and tell you the truth about how he or she became a judge of the High Court or the Supreme Court. Why? Fear. If I say this, मुझे क्या हो जाएगा? मेरा आगे elevation और आगे रुक जाएगा, मेरा बढ़ जाएगा. And therefore all this newfound feminism about first woman Chief Justice of India and all, this is all populist rhetoric. What will one single woman Chief Justice of India will be able to do? Nothing. She'll be surrounded by men who are more determined than her. So therefore the whole idea of Keshwananda Bharati as being a watershed in the history of India is an idea that has lost its political relevance, and of course daily loses its legal relevance by simple non-implementation by the Supreme Court of India. It couldn't stop the emergency. It couldn't stop the events subsequent to the emergency. It couldn't stop the 9th schedule events, couldn't stop Minerva Mills, couldn't stop Vaman Rao. And after that, what is the way that they found? 9th schedule, you draw a line. 24th of April, 1973. Then you again draw a line in 1980 and 81, Minerva Mills and Vaman Rao. And then what does the Supreme Court do? Please have a look at this judgment, Francis Corali Mullin versus Union Territory of Delhi. It is 1981, 1 SCC 608. Look at what the Supreme Court has done. It struck down in Vaman Rao that you can't make directive principles wholesale, ride roughshod over the fundamental rights. It struck down on that ground. And they said you can't oust our jurisdiction to examine this. So, what did it do in Francis Corali Mullin? It picked up wholesale, almost word for word, the directive principles from the articles and planted them in Francis Corali Mullin and made them into fundamental rights. The minimum right to shelter, minimum right to education, minimum right to nutrition, minimum right to medical care, minimum right to livelihood, minimum right. I mean, there's a list. It's almost like a politician giving a speech and declaring, मैं आपको ये दे दूंगा, I'll give you this, I'll give you this, I'll give you this. So, it's very difficult to imagine some of our highest educated judges and able judges doing this kind of a thing. Why they did it, only they can tell. Some of them are even no more. But the damage it has done to the Indian polity and the Indian people is immense. The damage is that the Supreme Court has almost no role in the daily life of the people of India. It has no role because they get nothing from it. And therefore, the Supreme Court has till today not been able to devise a mechanism to enforce its judgments. even where it delivers judgments, there is no mechanism set up by it to enforce its judgments. At the most, what will happen, you go and file a contempt, then for months together, you keep on lingering for the contempt. Then if certain feelers come from somewhere, your contempt will never be listed or will not be heard. And then after that, by the time God has kissed you and probably taken you away, and that's where you ultimately end up. Migrants, take the recent problem. There is more than enough law. Take the legislation on migrants. I mean, the legislation is defective, very defective. But whatever it is, you have to see to it that this defective legislation works. It's your job to make the machinery work. Because in way back in 1990, when did this come? Vishaka versus Union of India.
1997, sir.
Yeah. So way back in 1997, you declared that you also have another power. You have the power of interim legislation. Imagine, I mean, the Supreme Court says, we have the power to legislate in the interim till Parliament passes a law. What happened then? If acts don't work, you have the power of interim legislation, then set those acts right. Or get the government to work on those acts and report back to you within a specified time that, look, please tell us what are you doing. So the whole thing has worked into a delusion. And of course, unfortunately, our media makes heroes out of the judges whenever they declare something like this, and you'll get broad headlines and you'll get front pages and you'll get editorials and so on and so forth. Which only makes the judges feel that they are doing the right thing by not implementing, by not enforcing. Look, we only declared and people are so happy. As far as the media is concerned, media is so happy. And media has the pulse of the people. So that's it. I want to draw your attention towards the end to one major judgment. A.N. Raj versus Chandigarh administration. This is a judgment of 3 judges given on July 8, 2020. In this judgment, and it affects a very sensitive section of the population, the disabled, whereunder the India has signed the Convention on the Rights of the Disabled, and therefore India is bound to enforce that convention. And then, of course, we have the Rights of Persons with Disabilities Act 2016. Now, these 3 judges, what have they done? They have declared that disabled are entitled to everything that the SC and ST are entitled. So you have made the disabled SC and ST, I mean, equivalent to them. Now, only the President of India can add to the list, and only Parliament under our Constitution can alter that list. But you have declared you are 3 judges. You require 5 judges for such a major constitutional interpretation. You have made them SC, STs. There's going to be further trouble on this when people rush to the courts for implementation. As a matter of fact, it's already in trouble. The other thing is that look at the judicial technique. The judicial technique by which this far-reaching constitutional change was declared in A.N. Raj was an order. It was not a judgment. So therefore, there is no reasoning. It's an order. You don't have to give detailed reasons at all. So no reasoning. a declaration of a constitutional change in the status of the disabled, including the change of SC/ST classification, and they have, their words are, at least they are entitled at least to the same facilities as the SC/STs. So I don't know what else they had in mind apart from, in addition to the traditional facilities, that is reservations, etc. And mind you, the disabled already have a reservation of 4% in all government jobs. That is in all, it's a complicated language about cadre strength and all that, but in all government jobs, broadly for the moment, this will do. Now, what happens to that reservation? 4%. Is SC/ST in addition? Why is this far-reaching? Because SC/ST reservation is far more than that for the disabled. Number one. Number two, in all examinations, the eligibility marks for SC/ST are much lower than for the disabled. So therefore, there's a massive change in the equality of opportunity, which is a fundamental right for the disabled. So this kind of judicial approach, and this is what I want to point out, it seems that the Supreme Court is becoming reckless. You know, they have a sense of power and gradually of arrogance, institutional arrogance, that whatever we say is going to be binding, and for whatever we say, there are no consequences. For whatever we say, we are not going to enforce it anyhow. The enforcement, according to them, is the job of the executive, is not our job, forgetting the words in Article 32 of the Constitution. And this gradual arrogance is reflected increasingly in the proceedings of the Supreme Court, in the allocation and prioritization of matters in the Supreme Court. If the basic structure were really to serve the people of India, what is the question that the Supreme Court should have asked? The basic question they have to ask is, look, it is well understood, requires ordinary common sense, that you can't have fundamental rights without directive principles. They are meaningless. Without minimum nutrition, clothing, shelter, etc., what fundamental rights can you have? So therefore, the Supreme Court of India should have said, okay, please bring your budget, your annual financial statement produced before Parliament every year, and show us how far you have implemented the directive principles, which are declared by the Constitution in the very opening paragraph as fundamental in the governance of the country. So let us examine how you are governing the country. Where is the money of the people of India going? The money of the people of India, is it going to areas and to persons and to projects which really mean something for the people of India, or is it going elsewhere? And I'll just leave you with this indicator. People are suffering. Corona is there. What happens? Stock exchanges are going up. The value of shares on the stock exchanges is shooting up. Why? Why is the stock exchange so out of sync with the condition of the people of India? If some people are making a killing at the stock exchange, in spite of the suffering of the people of India, then there's something radically wrong. There's something radically wrong in the governance of India. Where is that money going? If you see the gold imports of India, rise more and more the crisis. Who is importing that gold? Who has that money to import all that gold? Why are these? And you know, gold is basically Hawala market. So therefore, money laundering, therefore. So is the money of the people of India going into these activities? Or is the money of people of India going into what they need? That is in terms of the directive principles. And therefore, please don't be surprised when you read a United Nations report or some other agency's report, or sometimes even our internal NSSO survey reports, that the children of India are increasingly stunted, and therefore are going to suffer. And this is the kind of India you're going to have in the future. Does it bother these reports? Do they bother somebody? Does it bother the Supreme Court? Look, these reports are there. They have no vested interest in writing these reports. Or you tell us that these figures are wrong because they are based on field surveys, actual surveys. You tell us these figures are wrong. You tell us what is wrong with them, and we'll see then what can be done about it. Nothing. So therefore, there is not even an inclination at solving the problems of the people of India. And if you don't have that inclination, then nothing can be done. At that level, what can you do? So therefore, the basic structure has only stopped for the moment, the political movement of India, in what would have been a natural conclusion of politicians taking absolute and complete power, and then let the people react, because that would have enabled people of India, the politics of India to evolve. Struggle. Without struggle, there is nothing. Without discomfort, there is no creativity. So therefore, the struggle and the discomfort has been taken away and hidden under the carpet called the basic structure. And that is where we ultimately rest. Absolutely the last point. There is a great weapon in the hands of the Supreme Court of India. And it is again part of the directive principles. It is called legal aid. It's a huge establishment. If you come to the Supreme Court, you'll see it's a huge establishment of legal aid with offices scattered around various parts of New Delhi. If you read their charters, legal aid for children, legal aid for poor, legal aid for the girl child, legal aid paralegals, this, that, the whole works. Where is legal aid whenever the people of India suffer? Right now they are suffering, migrants. Is there any sign of legal aid? Nothing. Where is that legal aid? And yet, Parliament allocates crores of rupees in this budget every year to legal aid, which is distributed through the Chief Justice of India. The money is distributed through the Chief Justice of India to the justices, to the judges, Chief Justices of the High Courts, and the Chief Justices of High Courts further distribute that money right down to the taluka courts, village courts. So legal aid formally is present everywhere, but the result is nowhere. So basic structure, nice words, borrowed as usual from abroad. Like you read the privacy judgment. What is it? Page after page of foreign judgments. Page after page of foreign judgments. What are you talking about? You're talking about privacy in India, not in the United States, where people have one religion, one language, and none of the basic problems of minimal existence. The state steps in for the minimal existence. But here you have nothing. You have nothing. You are talking of privacy. And I will request you to read Chandrachud's judgment in Olga Tellis. It's a beautiful literary passage in which he has captured the plight of the pavement dwellers of India, women and men and children living on the pavements, and how he has described their life. Another judge worth reading is Katie Thomas, who has described Bombay. So it is not, the problem now is that we have stopped having judges like that. We don't have a Chandrachud like that. We don't have a Katie Thomas like that. We simply have stopped. So just, again, I come back, I laugh at this because simply having a woman judge is not going to help you. How does it help you? You want a judge. You want a judge with a place in his or her heart for the people of India in terms of what you have already laid down. And you intend seriously to implement what you have laid down. So therefore, I congratulate the law school for organizing this, for celebrating this. And I wish all of you great success in your venture. So thank you very much.
Krishna sir, just one point of addition. I know you love your privacy a lot, but can you lower your camera a little?
Camera.
Yeah, a little.
Is it all right
Yes.
now?
Yes, perfectly fine. Sir. Yes.
No, I have no problems with privacy. You can come and examine my income tax records also. I have no problems.
Yes, Vandana?
So I have just one question.
Yes, sir.
Sir, can we say that the judgment of Keshwananda Bharti is more politically inclined than the judicial judgment has to be?
You're asking me?
Yes, sir. Yes, sir.
Jagtap? As I said, it was the result of a reaction to a political situation, which the judges could steep. And if you go back 70s and all, you'll find Subbarao, the dissenting judgment. Yogesh will tell you more about that. Now, he was the arch dissenter of the Supreme Court. And Subbarao was hammer and tongs at the government. He would say, no, danger. Of course, he had a different perspective. He would say, property rights will go. Most of India's people don't have property. So property rights will go, it's all right. But he was predicting anarchy. He was saying if we allow the politicians to continue the way we are continuing, they want to continue, there'll be nothing left. So the Supreme Court of India has reacted not immediately, but over a process from Subbarao, and then later on the Keshwananda Bharati emergency, and then you can see further political developments if you put them in that context. So, I mean, Constitution has a very close link with politics anyhow. It's law and politics always.
So because Justice Sikri was also part of the bench which delivered Golaknath judgment, majority judgment.
Yes.
Yes. Yes. Thank you, sir, for your enlightenment and for the insight of the judiciary and the Supreme Court, how Supreme Court deals and all. So thank you very much for your
Thank you very much. Thank you for listening.
Yes. So now I would like to call Dr. Yaniv Roznai sir to enlighten us with his thesis of constitutional amendment. And sir, with related to it, I have one question to it. Sir, if we see that in current scenario, the constitutional amendment is on rise. So can we say that the world is moving towards stagnant? Means they are repulsive of change. So isn't it a bad sign for us that we are not allowing the change, because we know that change is the only constant thing, but we are stopping that change? So how far is it? Where will it lead to us?
Right, thank you very much. Hello, everyone. I hope you can hear me well. It's a great pleasure to be here. I'm honored. It's noon here in Israel, but good evening to you all. So what I would like to do in the 20 minutes or more or less I have, I want to talk indeed about the success or the alleged success of the doctrine worldwide. I'm not going to focus on India, but then I will focus just to connect it to the theme of this evening, to populism and democratic erosion, and what are the challenges of what we see to the basic structure doctrine, or I'll just say the doctrine for the sake of ease. So we all know that the doctrine has become one of the most famous experts in global constitutionalism, right? It migrated from Germany with the assistance of Dietrich Conrad to India, and from India, it has migrated to many other places around the world: Bangladesh, Pakistan, Kenya, South Africa, Taiwan, Colombia, Peru, Belize, Malaysia, Uganda 2 years ago. And for what I see as a huge development, 2 years ago, in January 2019 in Slovakia, the Constitutional Court of Slovakia held that the Constitution contains an implicit substantive core which consists of principles of democracy and the rule of law, and that even constitutional laws cannot violate this implicit substantive core, and that the court, even without any explicit authority, has the power to examine constitutional amendments vis-a-vis this implicit substantive core. Now, this is the Indian basic structure doctrine, but this is important because this was the first time in history where a European court invalidated a constitutional amendment not based upon an explicit eternity clause, like in Germany or the Czech Republic. So this was actually a formal endorsement of the Indian basic structure doctrine in Europe. But what I want to ask in this talk is actually, can the doctrine assist in saving democracy in the era of populism? And I will doubt it, and I will suggest maybe some changes to the doctrine. So in recent years, as we all know, the world is experiencing a crisis of democracy. There's no way else to put it. If you look at the Freedom House report of this year, 2021, it shows you that 2020 marked a serious crisis of democracy and recorded the 15th consecutive year of decline in global freedoms. Moreover, the proportion of not free countries is now the highest it has been in the past 15 years. And what we see around the world is populist leaders abusing constitutional mechanisms such as formal procedures of amendment in order to erode the democratic order. Now, these changes very often are gradual, incremental, and subtle. Each constitutional change on its own may not necessarily amount to a serious violation of essential democratic values. But when you examine these changes in the context of an ongoing process, such changes may prove to be part of a democratic erosion process in which the whole is greater than the sum of its parts. So Tom Ginsburg and Aziz Hook, in their recent book, they explain that democratic erosion is a slow version of democratic decay. They define it as a process of incremental but ultimately still substantial decay in the basic predicates of democracy: competitive elections, liberal rights to speech and association, and the rule of law. And if you look around, Hungary, Turkey, Poland, and Venezuela are just some of the examples of countries in which such processes take place. Now, of the various measures that are employed by current populist regimes to erode democracy, formal constitutional amendments is notable. So, if in the past, authoritarian leaders assumed to be hostile towards constitutionalism, which was perceived as limiting their powers, nowadays populist regimes use constitutional law to advance their goals. This has been described in the literature as abusive constitutionalism. And especially with relatively flexible amendment process that is controlled by a dominant party or the government, like in Hungary, abusive constitutionalism then becomes attractive. Now, if formal constitutional amendments are a central mechanism in the service of those leading the process of democratic erosion, then prima facie, the doctrine, the basic structure doctrine that sets various limits to formal constitutional change, seems like a useful tool to block or to hinder such changes or of abusive constitutionalism. Is it? And here I want to suggest three features of today's trend which impose various limitations on the doctrine itself. But before I do that, I'll just say very briefly why the doctrine is considered to be quite a useful tool in the hand of democracy. So I don't need to explain to you and to the audience the doctrine, you're all familiar, but I'll just say that around the world, the doctrine has proven to be quite a useful stop sign or a speed bump against amendments by political leaders aiming to erode the democratic order. So, for example, in Taiwan in 2000 or in Uganda in 2018, courts have declared amendments that extend the term of legislators to be unconstitutional based upon the idea of implicit limits on the amendment power. And indeed, when courts declare amendments that would significantly harm the democratic order as unconstitutional, this declaration can slow down authoritarian initiatives, perhaps up until other political actors gain powers, or even completely stop such initiatives. I'll give you just one example, the term limit saga in Colombia. In 2002, President Uribe was elected, and he turned to be a very popular president. But the constitution limited presidential term. So Uribe, he wanted to amend the constitution in a way that would allow him to run for a second term. In 2005, the court examined the constitutionality of that amendment, declaring it as valid. And then after another successful term, Uribe wanted another amendment that would allow him again to seek a third consecutive term in office. This time, the Constitutional Court, without any explicit eternity clauses, held that the third consecutive presidential term would concentrate too much power within the executive and cause severe damage to the institutional checks and balances. And accordingly, they held that this amendment would be an unconstitutional constitutional replacement of the constitutional order with a new one, and declared it as invalid. And after this dramatic ruling, again against a very popular and powerful president, Uribe left power peacefully. So through the use of the doctrine, or a version, the Colombian version of the doctrine, the judiciary played an important role against democratic erosion. So these examples and others show that the doctrine can indeed quite be a useful tool against populist constitutionalism. But in the current wave, the doctrine has several inherent weaknesses. And I will just emphasize three central weaknesses. The first one is incrementalism. Nowadays, democratic breakdowns occur not by an immediate break, a sudden suspension or destruction of the constitution, a coup d'etat, or one amendment that says that the country is no longer a democracy, but a fascist regime. We don't have these things. What we have elected governments using, abusing, and subverting the democratic institutions themselves. But these charismatic leaders, they use legal means and subtle means to ultimately dismantle the constitutional system. As Professor Kim Lane Shepley states, she says, if you're a foreigner visiting this country, the country looks perfectly normal because there are no tanks in the street. Okay, so that's the problem. One of the main elements of democratic erosion is incrementalism. It is typically an aggregative process made up of many small increments. But these measures are rarely a frontal assault on the basic principles of the constitutional order. And this is why it's very difficult to spot democratic erosion. And because there is no direct assault on the Constitution's fundamental principles, the utility of the doctrine is fairly limited. The doctrine wants to preserve the core identity of the constitutional order and its fundamental values, but it allows small-scale infringements, even of the protected principles. So the doctrine basically allows for an incremental, gradual crumbling of the constitutional order brought about bit by bit. So it is almost useless against democratic erosion. As Levitsky and Ziblatt write in their book, How Democracies Die, the assassins of democracy use legal, subtle, and gradual means to kill it. And I add, and the doctrine helplessly stands aside, witnessing this assassination. The second feature is complete constitutional replacement. The doctrine is the result of the limited power of the formal amending power. But what if the change is brought about not through the exercise of the limited amendment authorities, but by the original constituent power, by a new constitution-making process? So what if abusive constitutionalism is taking place not in the sphere of amendments, but in that of a completely new constitution, like occurred in Hungary, where they simply brought a new constitution? So the doctrine rests on the distinction between primary and secondary constituent power. It protects the people's constituent power expressed in the constitutional fundamental decisions vis-a-vis the more limited amending power of the constituted organs. So while the doctrine limits the amending power, it doesn't, and at least conceptually cannot limit the exercise of primary constituent power. So leaders may simply circumvent the doctrine by completely replacing the constitution with a new one, as we've seen in Venezuela or in Hungary. So that's the second problem. The third problem is attacking or packing the court. The doctrine shifts the locus of constitutional change from the political authorities to the judiciary. This is part of its strength, but it is also part of its weakness. Because in the era of populism and democratic erosion, when politicians realize that the ultimate decision regarding constitutional change rests with the judges, then courts are packed or threatened in ways that make the doctrine impossible to deploy. Take, for example, Venezuela, Turkey, Hungary, or Poland, where you simply capture the court. So accordingly, even if in theory the doctrine can be a useful tool against abusive constitutionalism, the ability to pack the court and control it severely undermines the utility of the doctrine. Now, it's not only that the doctrine in the era of populism is useless, it's even worse. As a powerful tool that can override constitutional provisions, a packed court can use this powerful mechanism at the hands of the political leaders, providing them another powerful tool to perpetuate their stay in power. And if you can look, there are various recent cases in recent events in Latin America where courts have used the doctrine, packed courts or captured courts have used the doctrine not to limit presidential terms like in Colombia, but to prolong the presidential term. So the courts, these captured courts have held that presidential term limits violate the implicit core fundamental rights, the right to be elected and the right to vote. So this occurred, for example, in Nicaragua, in Bolivia, or Honduras. So with the captured court that has also the tool of the basic structure doctrine, the politicians have unlimited powers. I'm almost done. So I want to conclude, how can we deal with this? What can the court do in light of these challenges? The first thing I want to present is an aggregated judicial review of amendments. Because the doctrine now fails to address incremental minor changes, something has to change, because these minor changes can have an aggregated effect. The quantity at a certain point turns into quality. So I think there's a need to consider an aggregated form of judicial review of amendments. Assume the ordinary scenario. Each amendment on its own has a minor effect on the specific constitutional principles. But if the court would say, wait, when this amendment is now added to the prior amendments, the effect on the protected principles is already substantial. So an aggregated and accumulative judicial assessment can actually better assist the incremental challenge of populism. So that's one thing, an aggregated review. The second thing I want to suggest is a review of not only amendments, but a total constitutional replacement. Because now constitutional replacement is another tool for abusive constitutionalism. And think of Hungary for a second. When you have an amendment, the court could, in theory, control it through the doctrine. But if now the government uses the same procedure to bring about a completely new constitution, now the document is shielded from review, even if it was exercised, the constitution making process was exercised by the same 2/3 majority. This to me doesn't make sense. Now, I'm not sure by which theory, but there are some theories around there, like those suggested by Carlos Bernardo, Kimlin Chepeli, that one can also control the legitimate exercise of a new constituent power. That's the second point. And the third point, and then I'm ending, I think that a special attention should be made to those amendments affecting judicial independence. Because one of the challenges of the doctrine is court packing and weakening the judiciary. So perhaps in a democratic erosion context, courts should be especially aggressive in protecting their independence. And if you look at recent cases from Bangladesh, India, and also the Slovakian case. And considering what we see in places like Poland, Hungary, and Turkey, I think that in the context of abusive constitutionalism, the court's aggressive application of the doctrine in cases concerning judicial independence make more sense. So when I wrote the book in 2017, I was critical of the Indian judgment regarding judicial appointments. This is a violation of the basic structure doctrine that the judges won't have veto power on judicial appointments. This didn't make any sense to me. I was against it. But perhaps in the context of democratic erosion and populism, it makes sense. We need to be especially militant in protecting judicial independence, because only through that we can protect other democratic institutions. So just to conclude, our basic assumptions must be reconsidered. Instead of using judicial doctrine to protect against revolutionary amendments, we need to adapt the doctrine to existing constitutional practices that utilize incremental and subtle amendments to dismantle the democratic order. And just to answer Jacques' question from earlier on, it is true that the doctrine has been highly successful, which means on the one hand, you want to protect the status quo. But what is interesting is the move that we see now towards also illiberal trends by using the doctrine, as I mentioned in Latin America. But there is another interesting trend. It is also against another advancement, not only internally speaking, but externally. If you look at Europe, what you see courts around Europe, Germany, Italy, Hungary, of course, the Czech Republic, using the idea of the doctrine against what? Against European integration and against EU law, where they're saying, no, we don't want these laws because these European laws might violate our basic constitutional identity, which we want to preserve through the doctrine. So it's interesting. It's interesting because the doctrine plays here a double sword in a way, also internally, but also externally. So I find it quite interesting, and we'll have to wait and see where it goes. I can only say that recent events in the recent 2-3 years show that more and more courts are willing to adopt the doctrine in their own version. Also, perhaps even in Israel, we will see there are some very important cases pending now here. So thank you very much for the invitation, and I'm looking forward for the further discussion.
So a question to you about that. So if we allow court to interfere in the matter of like judicial or executive or to anything, means court can judicial review of executive matter or administrative matter. So sir, isn't that they have they have no public mandate behind it? On the other hand, if we talk about the parliament, they have public mandate, they have public power behind it, but it's lacking in judiciary. So doesn't it lead to against the public mandate?
That's a great question that I think is I think it's highly relevant, not only when reviewing executive, but also obviously ordinary legislation and also amendments. The problem is that the court obviously has no sword and no purse, as we know it. It rests on public legitimacy. And judicial review of amendments is the highest, let's say, scenario of judicial activism, as you guys know it. It brings to the fore this battle between the branches. Therefore, I think that this power should be used extremely carefully. The court should not exaggerate when using the doctrine in order to preserve some of its legitimacy. It is true, and I agree that at least in theory or conceptually, if the doctrine applies to the amending authority, all the more so it should apply to other constituted organs such as the executive. For me, sure, but the standard of review should then be quite restricted when reviewing these actions. So I'm not sure. It is always contextual in the sense that every jurisdiction and every court in each jurisdiction has its own legitimacy, and I'm not sure, how much legitimacy can you spend by over using the doctrine. What is clear, and here this is a recent piece I authored with 2 political scientists. When courts already have the power to review amendments, like in Brazil, for example, the court then has less to fear from political overrides or backlashes, because it already has some kind of a legal tool to deal with these when they arrive. In contrast with a court that has, for the first time, to do this issue. But I certainly agree, and this is important, courts themselves cannot protect democracy. I have to be clear here. Courts are not the heroes here. Courts on their own cannot save democracy. What you need Democrats, small c Democrats, the people, the society who care about democracy and understand its importance, that are willing to back the court in these cases. But this is, of course, a wider social issue.
Yeah, just one point of addition to all the participants attending the lecture right now. You can post your question in the chat box, and we will highlight them in the Q&A session separately. Yes, Ashutosh?
Thank you, sir. Thank you, Yaniv, sir, for your overall perspective of the entire world order. And sir, Vandana, are you there?
Yeah, am I audible?
Yes.
Am I audible clearly?
Yes, Beta, you are audible.
Okay, so now I would like to call upon Yogesh sir to deliver his views on this particular question. That, sir, what's your opinion on the role of Supreme Court in analyzing and applying the basic structure doctrine? As the doctrine of basic structure was evolved with an objective to safeguard the fundamental rights of the people. But the application of the same doctrine has took a very different road. As in the recent times, the application of doctrine seems to be an overreach by the judiciary, and which actually tries to show its primacy and supremacy over other organs of the constitution. So, sir, what are your views on this particular aspect?
Yeah, I'm audible, Vandana?
Okay, sir. Yes, sir, you're audible.
Okay. Thank you. Thank you all to Ashit and Center for Constitutional Law, National Law University, Jabalpur. I'm indeed privileged to be part of this panel. Professor Krishna Mahajan, my mentor, my guide, Professor Yaniv Roznai, for a very informative and good lecture on basic structure across the globe. It is very difficult to speak on any topic, especially on judicial decision making, after Professor Krishna Mahajan sir. He is a staunch critique of Supreme Court decision making, and rightly so. I have learned many things. I say rightly so because we find Supreme Court failing us when we need the support from the Supreme Court as the highest court of the land. He rightly mentioned that Supreme Court could not stop emergency. In fact, it helped government to sustain the emergency and to stabilize more powers. It is helping government even now in a similar set of circumstances where we don't find any kind of limitation on the power of the government. Sometimes, therefore, I think that do we have a constitution at all? Or we may have a constitution for the sake of argument, but do we have constitutionalism? Because the whole debate of basic structure, constitutional amendment is with respect to constitutionalism, which is the sense of any constitution. And in ontological sense, its constitutionalism is seen in the articulation of devices which controls the governmental power, political power. Constitutionalism means that all power rests on the understanding that it will be exercised according to commonly accepted principles, that the person on whom power is confirmed are selected because it is thought that they are mostly likely to do what is right, not in order that whatever they do should be right. And this was one of the apprehensions raised, I always say, in the Constituent Assembly by Dr. Ambedkar and Dr. Rajendra Prasad both, that we can draft even a better constitution if we compare with the existing one. But that constitution will fail if the people who are going to administer this constitution, if they are not good. And an average constitution may function if the people who are going to administer they are good. So constitutionalism and constitution, the whole idea of constitution, written constitution, normative constitution, controlling constitution, whatever we say, comes with this one essential quality, that is legal limitation on political power, legal limitation on governmental power. Indian constitution was also based on this liberal ideology of constitutionalism, and therefore all powers are limited. We cannot visualize the concept called absolute power or unfettered power in a normative constitution. The moment you adopted a written constitution, the moment you claim that we have constitutionalism, there cannot be an absolute power. So when first time this question was raised, and this question was raised right when the constitution was implemented and the first constitutional amendment was made, whether parliament's power to amend the constitution is limited or absolute. As a common man, ordinary man, as a law student with ordinary average mind, I would say no, there cannot be an absolute power. Because the whole idea of constitutionalism, written constitution, normative constitution, denies this absolute power concept. But the Supreme Court took 23 years. Indian Supreme Court took 23 years to say that power under Article 368, power to amend the constitution, is a limited power. I will not go into the details. Shankari Prasad, when Supreme Court accepted that government has unfettered power or parliament has unfettered power, I will use this word interchangeably sometime, because this is a Westminster model. Sometimes it is difficult to differentiate whether what is government, what is parliament. So in Shankari Prasad, the Supreme Court accepted that government has unlimited power to amend the constitution, including fundamental rights. So they can do anything, whatever they want to do. This view was reiterated again after a decade, when the validity of 17th constitutional amendment was challenged. Again, a very famous case, Satyan Singh versus State of Rajasthan. The Supreme Court, with a majority, again this is a 5-judge bench, constitutional bench, with a majority upheld the constitutional validity of 17th Constitutional Amendment Act. But the highlight of this case was not the majority opinion. The highlight of this case, Satyan Singh versus State of Rajasthan, was the two concurring opinions, one written by Justice Hidayatullah and the other written by Justice Madhulkar. Concurring opinion, you know the meaning of concurring opinion. It is not dissent. Judges can write dissenting opinion, judges can write concurring opinion. Sometimes they write partly concurring, partly dissenting. But concurring opinions are those opinions where you agree with the majority in conclusion. So these two judges also agreed with the majority that 17th Constitutional Amendment Act is constitutionally valid. But they raised serious doubts on the majority. And Justice Hidayatullah said that I would require stronger reasons than those in that case to make him accept the view that fundamental rights were not really fundamental, but were intended to be within the power of amendment, like other parts of the Constitution. The Constitution gives so many assurances in Part 3, and it is very difficult to think that they are a plaything in the hands of a special majority. Plaything in the hands of a special majority. If government has a special majority in the Lok Sabha, government has majority in the Rajya Sabha, it is not a very difficult proposition. Nehruji had majority in both the houses. Indiraji had majority in both the houses. Rajiv had majority in both the houses. And this government is also now getting that privilege. In fact, super special majority. You have more than you have government in more than half of the states. So you can in reality you can amend any part of the Constitution. Justice Madholkar, probably he was first time he was using this word, and in his concurring opinion he said that there are certain fundamental features of the Constitution which cannot be changed. In fact, each and every constitution of the world has certain fundamental features. So this was the impact of these two strong concurring opinions, that the same issue, means the constitutional validity of 17th Constitutional Amendment Act, was again referred to a larger bench, 11-judge bench in Golaknath case. Some scholars, as Professor referred, that the origin of basic structure lies in German literature. Professor Conrad. And he also, it was so that he delivered a talk in 1965 in Banaras Hindu University, and the title of his talk was Implied Limitation on the Amending Power. And this was the time when this power tussle was going on between government and the Supreme Court. You know the history. The 11-judge bench in Golaknath case, the majority led by Justice Subbarao, Mahajan sir mentioned, a very strong dissenter of the Supreme Court, but this time he was in the majority. He overruled earlier two cases, Sankari Prasad and Sajjan Singh. And he said that fundamental rights are not amendable at all. Inviolable rights beyond the reach of Parliament. And the Supreme Court denied. It seems a political judgment. Justice Subbarao accepted also some in private discussions, conversation, that he knew that he is crossing the limits. He is going beyond the mandate of the Constitution. But in spite of that, he wanted to stop the unruly horse, the government. He said that this is not, Article 368 does not confer power on the Parliament to amend the Constitution. It only talks about procedure. because the marginal note of Article 368 provided only procedure to amend the constitution. So he said that there is no power. Power you have to derive from some other provision. And where is other provision? You have to derive from Article 245 to 248, ordinary lawmaking power. And when question was asked that ordinary legislative power you have to read with Schedule 7, and there is no subject either in the union list or in the concurrent list on amendment of the constitution. He also gave solution that you can exercise your power under Article 248 read with entry 97 of the Schedule 7 union list. Residuary clause, something for which one whole part of the constitution was devoted for one article, Article 368. Justice Subbarao suggested that you can derive this from entry 97 of the union list and Article 248. This question was also asked that suppose, assuming that we do not have power to amend the fundamental rights, but what if the whole country demands that there should be a change in fundamental rights? This might happen. If there is a movement, he again suggested that if you want to really change fundamental rights, you have to recall the Constituent Assembly. But again, that power is not given under the Constitution. Where is the power to recall the Constituent Assembly? He again gave a solution, Article 248. If power is not expressly mentioned anywhere, you can exercise the residuary power. So political judgment, but huge impact. 24th amendment was passed. In fact, a private member bill was also introduced immediately after Golaknath judgment by Barrister Nath Pai, a member of parliament, but it was not taken seriously. And finally, Parliament enacted 24th constitutional amendment in 1971 and drastically amended the constitution, including Article 368. It was so scared, the government was so scared of the Supreme Court that for the similar purpose they amended the constitution twice. A clause was added in Article 13, similar clause was added in Article 368 also. One was suffice. But to remove any kind of doubt, difficulty, they amended the constitution. And finally, the Supreme Court and this was again challenged in Supreme Court, and we have now, for which we are discussing today, on 24th April 1973, the 13-judge bench in Keshwan and Bharti, the fundamental rights case, majority 7:6, very thin majority. There are problems even on the majority minority question also. Mahajan sir he would appreciate that some people say that this basic structure doctrine was not given by the majority, because Justice H.R. Khanna, on some points he was with the minority, on some points he was with the majority. So it is not very clear that whether basic structure doctrine was given by the majority actually. But finally, the Supreme Court built the superstructure on the premise foundation which was created by Justice Madhulkar and Justice Hidayatullah in Sajjan Singh case, influenced by German professor Conrad. A harmonious construction was done, was evolved, And this doctrine of basic structure was conceived by the Supreme Court, which means that there is a implicit, implied limitation in the Constitution. The American doctrine of implied limitation was legitimized in the form of basic structure. It was criticized on several grounds that this does not have any textual background. So from the text, if you read Article 368 carefully, you will not find any textual justification. So this is completely a foreign new doctrine which was borrowed by the Supreme Court. But I find that there was and Supreme Court also justified, which I find justifiable, that if you read Constitution Article 368, you will find this phrase, this Constitution. This Constitution and the Constitution shall stand amended, which makes it sufficiently clear that after making the amendment, whatever amendment you want to make in the Constitution, including the chapter of fundamental right, the residue which is left, the remainder which is left, should be this Constitution which was drafted by the Constituent Assembly. So any stretch of change under Article 368 cannot create a new Constitution, because then we cannot say that this is the same Constitution which was drafted by the drafting committee headed by Dr. Ambedkar. And this understanding was also sustained by literal meaning of word amendment, which means a minor change or addition designed to improve the text. Therefore, for an amendment to be constitutionally valid, the Constitution that remains after change, modification, amendment must be the same Constitution with all those essential features which were present at the time of its conception. The problem with this doctrine was that the Supreme Court failed to give a concrete shape in Keshwan and Bharti, and they said that this will be decided on case-to-case basis. This seemed to be undemocratic. In a parliamentary democracy, it is the parliament which is sovereign, which has the lawmaking power. But now Parliament would not know that what part of the Constitution can be amended and what part of the Constitution cannot be amended. You amend the Constitution, then it will be challenged, and some Supreme Court will find that no, this is part of the basic structure, and they will struck down. The second problem with this was the power clutching attitude of the Supreme Court. The entire Constitution may, one by one, may be declared as part of the basic structure of the Constitution. And this is happening. This happened. And you will find after Golaknath, immediately after Golaknath case, which decided that government cannot change fundamental rights, you will find government became very active, very serious on the appointment of judges in the Supreme Court. The government now started hunting for so-called committed judges. Until 1970, the appointments were made by the government on the recommendation of the Chief Justice of India. So we don't find much disagreement between government and Chief Justice of India. But now this trend was changed, because you have cases, major confrontations in Golaknath, R.C. Cooper, Privy Purse case. And therefore, even after Keshwanand Bharti, you will find an attempt was made to review basic structure doctrine. This was also very surprising. A suo motu attempt. Everybody knows that after Keshwanand Bharti, we find first supersession of judges. 3 senior most judges were superseded, and number 4 judge, Justice A.N. Ray, he was appointed as the Chief Justice of India. And Justice A.N. Ray suo motu constituted a 13-judge bench, because a 13-judge bench can only review the 13-judge bench decision, basic structure doctrine. The hearing was also started. Everybody was surprised, including the great Palkiwala. He wrote, in fact, letter to Indira Gandhi also, that what are you going to do? Doctrine of basic structure will help this democracy to survive. And if you are trying to review this doctrine, I think we are going to face a difficult time. But in spite of that, the hearing was started, and Palkiwala was trying to convince Justice A.N. Ray and the bench that to review any judgment, this is not the way. The process is there must be some kind of dispute, some kind of application, some kind of disagreement, or there must be some development from judicial side that this requires a review. Then only you can review a judgment. And the Chief Justice, he, without realizing that the Advocate General of Tamil Nadu is sitting in the court, he said that we have received a letter from the government of Tamil Nadu, where government has requested that this case, basic structure, this doctrine should be reviewed, should be reconsidered by the Supreme Court. He was not aware that the Advocate General of Government of Tamil Nadu was also sitting in the court. Immediately he raised his hand and he said that no, my lord, we have not made such request. He lost his face and the bench was dissolved same day. So somehow basic structure doctrine survived. But there are problems. The other problem which doctrine of basic structure carries is the persisting dilemma which engaged the legal academia, is whether the basic structure doctrine can be applied to ordinary laws also. This doctrine was conceived with respect to Constitutional Amendment Act, constitutional law, not the ordinary law. So if you want to challenge a Constitutional Amendment Act, you can challenge only on one ground, that this violates basic structure of the Constitution. But the question was raised whether this doctrine can also be applied to ordinary laws. In Indira Nehru Gandhi versus Radzyner, at least 3 judges very clearly mentioned in the judgments the doctrine could be applied only to the amendments in the Constitution and not to the ordinary laws. Ordinary laws can be challenged only on 2 grounds. One, lack of legislative competence and violation of any of these fundamental rights under Part 3 of the Constitution. And basic structure can be challenged on the ground that it violates. Constitutional amendment can be challenged on the ground that this violates basic structure of the Constitution. In Kuldeep Nayyar, another very important judgment where Supreme Court failed us, the Supreme Court once again held that doctrine should be strictly limited to constitutional amendments. What happened in this case was Representation of People's Act 1951, very crucial legislation, and this law was also passed by the same Constituent Assembly which drafted the Constitution. So this was amended in 2003, and this deleted the requirement of domicile in the state concerned for getting elected to the Rajya Sabha. So any person now, and that's how Manmohan Singh got elected from Assam for the upper house. So domicile requirement was removed by this amendment, and this was challenged in the Supreme Court that this violates federal structure, which is one of the basic features of the Constitution. But the Supreme Court very clearly mentioned that no, this doctrine of basic structure can be applied only to the constitutional amendments and not to the ordinary legislations. But there are 3 cases prior to Kuldeep Nayyar where the Supreme Court has observed that ordinary laws or provisions of an ordinary law can also be declared unconstitutional on the grounds that this violates basic structure of the Constitution. And this is another general problem of the Supreme Court, decision making in the Supreme Court. It is consistently inconsistent. In DC Badhwa versus State of Bihar, the Supreme Court struck down repromulgation of ordinances in Bihar on the ground that this violates basic structure. In Lakshman Chandra Kumar versus Union of India, when first time Administrative Tribunals Act 1985 was challenged, along with the Constitutional Amendment Act, Article 323 capital A and 323 capital B. Again, Supreme Court recognized that this violated basic structure of the Constitution. Then Indira Sani 2, again Supreme Court observed that a state enacted law on reservation for the creamy layer violated the basic structure doctrine. This problem is not yet resolved. So still we have a dilemma whether an ordinary law can be challenged on the ground. I think that we can challenge, we should challenge on this ground. Where basic structure cannot be diluted in exercise of constituent power, how can government violate or dilute basic structure in exercise of ordinary legislative power? Otherwise, it will be easy for the government. They will not make any amendment in the Constitution. They will pass ordinary law and they will dilute basic structure of the Constitution, basic features of the Constitution. There are a number of cases which are pending before the Supreme Court where in some of them basic structure has been questioned, like Citizenship Amendment Act, CAA 2019. The center has not yet replied on this question of basic structure violation by this amendment. Reservation of economically weaker section, Constitution 103rd Constitutional Amendment Act, pending before the Supreme Court. Challenges to the revocation of Jammu and Kashmir special status, still pending before the Supreme Court. Now, Supreme Court has accepted a new trend, doctrine of postponement of important cases where government has a very high stake. They will not listen, even if it includes serious questions like personal liberty and habeas corpus. Electoral bonds case, very, very crucial. The Finance Act 2017 introduced electoral new bond, new scheme by the government so that they can institutionalize corruption and donation to political party. And this was observed that around 85 to 90% of the donations through this electoral bond is going to one specific political party, that is Bharatiya Janata Party, because it is anonymous. But in spite of that, Supreme Court is not, or Supreme Court does not think it is urgent or it should be considered on priority basis. So, in my opinion, basic structure doctrine fits within the larger scheme of constitutionalism and normative constitution, where we claim that no power is absolute power. But the way it has been interpreted by the Supreme Court, the way it has been applied by the Supreme Court, I find problematic. I find problems. So thank you very much for inviting me to this panel discussion. I think I have already taken much time. I should stop here and we'll thank you, Ashit, for organizing this interesting discussion.
Thank you so much, sir, for giving us this different aspect of all these judgments and the historical events in regards to the basic structure doctrine. So you just mentioned that there is no concrete basis and it's up to the judiciary to decide the basic doctrine case to case. So in regards to this particular statement, we are having a query in the chat box from Divyani Sahu. She says, what are the measures against basic structure doctrine becoming non-functional, as it is subject and is over dependent upon the Supreme Court's wish to implement the same?
What are the measures against basic structure doctrine becoming non-functional on account of being over-dependent upon Supreme Court's wish to implement it? Yeah, this is the problem I mentioned with the basic structure doctrine, that this was not given a concrete shape in Keshav and Bharti, and it was left on the discretion of the judges that they will apply this doctrine and they will formulate the concept on case-to-case basis. And this will create problem, because I always say that we don't have one Supreme Court. We have multiple Supreme Court, because our Supreme Court sits in benches, unlike American Supreme Court. And each and every bench is a Supreme Court in itself. And this is one of the regions of this, the problem which I mentioned, that this is consistently inconsistent. So one bench you have conflicting opinions. One bench in the selective wisdom they will apply and they will interpret in a different manner. Other bench will apply basic structure in a different manner. So this is the problematic area. I think we should be aware and we should be very careful when basic structure. In fact, this 13-judge bench, this was created this basic structure, but you find that this has been interpreted, this has been applied by division benches many times. So even a division bench, 2 judges bench, 3 judges bench have interpreted basic structure, they have applied basic structure. Mahajan sir can throw more lights on this. This is a real ongoing problem in the Supreme Court. We don't know what is going to happen.
So I have a similar question to what Vandana asked earlier. So we have limited the power of Parliament by adopting the doctrine of basic structure. But sir, we have given the upper hand of judiciary, which do not have any checks and balances above it. So means if Supreme Court finds legislature or a statute as a violative of doctrine, then it can do. So, sir, what is that check? What is the check and balance on the Supreme Court?
See, this I accept that this is a very relevant question. That every time when we talk about judicial review, we talk about limitation on the power, limitation on the governmental power. Supreme Court has exercised its power of judicial review, and they have tried to restrict the not only the legislative power but also the executive power. In fact, there are places where Constitution mentioned that there will be a bar of judicial review. The Supreme Court broken that limit also. Like ministerial advice. Constitution says you will not go into the ministerial advice. 9th schedule. Constitution said that 9th schedule was created only for this reason, that Supreme Court and High Court will not intervene. But in spite of that, you will find Supreme Court interpreting, Supreme Court intervening. So today, in spite of clear prohibitions in many places, many provisions, there is no place in the Constitution where you can clearly say that this is not subject to judicial review. So all provisions of the Constitution is subject to judicial review today. But when it comes to accountability of the Supreme Court, whether in terms of Right to Information Act, whether it in terms of fundamental rights, debate is going on right from the beginning that Supreme Court and High Court should also be declared as part of the state, because now they exercise more political power. But you will not find any concrete answer from the Supreme Court. American Supreme Court long back declared that writ can be issued against High Court and Supreme Court also. But Supreme Court and High Court is not part of Article 12 even today. There is no authoritative pronouncement. There is no accountability on part of the collegium. A body was created in 1993 and it was justified. It was justified that time, as Professor mentioned, because the kind of influence, the kind of interference the government was making in the appointment of the Supreme Court and High Court judges, the Supreme Court was forced to interpret that no, primacy of the Chief Justice of India we have to create. But when it comes to accountability on the part of the collegium, again we don't find any concrete answer. The memorandum of procedure is not yet finalized. So who is making a real appointments? Nobody knows. So you have to see this aspect also.
Sir, in the chat
Mahajan
box,
sir,
we
you
have-
want to add something?
Nothing. Yogesh, as usual, you've been brilliant. And thank you for tracing the evolution so carefully. I think the need for us to get together is this, that on these issues, that all of us don't have the complete information about the operation of the Supreme Court. Now, those of us who practice at the Supreme Court know for a fact that this entire collegium thing was a thing specifically maneuvered by certain lawyers of the Supreme Court, because they felt that their control over the appointments of judges was going to slip away. And these lawyers happen to be celebrated names. And if you see the judgments of the Supreme Court, there is a small judgment called Subhash Sharma versus Advocates on Record Association. Now, Subhash Sharma, these so-called celebrated eminent, they call themselves eminent jurists, these small, they successfully pushed out the petition of Subhash Sharma and substituted themselves as the main petitioners and took charge of the case. And then, of course, there seems to have been an implicit understanding that as to what is to be done. And in the name of resisting government pressure, what was done was that you gave in to private pressure. And therefore, what happens is that today amongst lawyers, we openly talk about that this court is the court of this industrial house, this court is the court of this industrial house, this court is the court of this industrial house. And there are good reasons for it, because lawyers representing these industrial houses in these courts stand up, and even if they don't argue, they get orders. They get orders which they need. And going down the long track of this Supreme Court role in revenue matters and economic matters, and again I tell you, all that matters ultimately, and even political power or judicial power, revolves around revenue and economic matters. This is all that matters. We have had to learn it the hard way by stumbling. Yeah, we were not brought up to find people disguising what they wanted and then discovering, and then it's very difficult to crack the disguise of well-educated and highly trained lawyers. So it takes you time to break through that. So the excise cases, for example, in all excise is the backbone of revenue of the government of India. Today it is GST. If you see those cases, you'll find in for about 7 to 8 years, one single lawyer representing every industry getting up and an automatic notice stay. It's almost like a money printing machine. You just see those orders. Now the problem is of information. The problem is that these orders are never published. They are just orders. So they are not published. Of course, another problem of Supreme Court information is that it is in a judge's discretion whether a judgment should be made available for public consumption or not. So where a judge has done something wrong, favored somebody, for example, given bail to a rapist, he will quietly mark it not reportable. And the judgment will never figure in the official reports of the Supreme Court. So therefore, the role of private power in the Supreme Court, and again, there has been a change. There was a time when private power represented good values. They represented values of liberalness. They represented values of democracy, of dissent, of getting on with people together and moving them together towards a destined constitutional goal. And then this private power became totally corrupt in the Supreme Court. And therefore, I must tell you that the key factor today, when you discuss the Indian judiciary, and of course, India as a whole, Indian judiciary especially, is corruption. The key factor is not what, basic structure or this structure or that structure. No structure can survive corruption. It is as blunt as that. Every lawyer practicing in the Supreme Court knows who is doing what are the money channels. Every lawyer knows where are the collection points, here or abroad. Every lawyer knows that. But as I told you, we live in an atmosphere of utter fear. No lawyer will get up and say, because next day, and this is another development in the Supreme Court, he is afraid that next day he will not get orders that he is fighting for from the Supreme Court, simply because he has had the courage to say that there is corruption in the judiciary. And this change that has taken place is, formerly the Supreme Court judges were not vindictive. At least till the time of Chandrachud, we used to have open battles with the judges. Disagreement, dissent, sometimes even anger across the bar with the judges of the Supreme Court. But that was it. It was over in the court. It was not continued and kept in the mind. Oh, this damn lawyer, he has to be taught a lesson. He has to be put in his place, or she has to be put in her place. Today, this is the problem. A lawyer dare not speak out or even argue fully and point out the consequences of what is being contemplated by the bench, because the vindictiveness, because he knows that from tomorrow onwards, it is like the army. the Major General or the Lieutenant General just picks up the phone and says, hey, blackball him. That's enough. So that person he's finished. So it's like that. It's this is what has happened in the actual operation of the Supreme Court. And one instance which came out openly, you saw, was Prashant Bhushan versus what was that judge? The judge from Madhya Pradesh in the Supreme Court.
Arun Mishra.
Arun Mishra was a disaster. I don't know how many of you have read his judgment on religion. It is about 150 page judgment on what? On the Mahabaleshwar temple in Ujjain, the Shiva temple. And it has no meaning. You read, you go through page after page. You know, the floor must be swept so many times. The water should be sprinkled so many times. The prayer should be held so many times. I mean, the man, what has a Supreme Court judge got to do with the rituals? And none of those rituals are under challenge. It is just that as part of environmental law, you pick up and you deliver a huge judgment on the religious aspect of one of the very ancient temples of Ujjain. Now, where is the accountability of that judge? There are things again which Yogesh and I know, which Arun Mishra was doing as a judge. But which we better not state. So the point is that each one of the judges today is a judge who is afraid of exposing himself to the public, to public scrutiny. That's why I said the point is how do you appoint the judges? And this collegium, what is this collegium? You've seen some of the instances have come. The current Sanjeev Khanna was appointed overnight by obliterating the appointment which had already been approved by the collegium. Why? Because he was backed by a former Attorney General who carries great clout with this government. He was backed by the private forces which want to have control over the Supreme Court. They know what Supreme Court means for their economic interests. The point is this, that unless you throw the Supreme Court open to public scrutiny, there cannot be democracy. There cannot be democracy. Because then what Professor Roznai has very categorically pointed out, you know, that incremental erosion that has been taking place over the last 70 years, gradually, case by case, bit by bit. And as I said, sometimes in orders, because orders are never published. So those who have an economic interest, they get an order of stay. And then after that, you have to pay 3 million rupees for the consumption of electricity tax. And you get a stay, and then you go and sleep. So it's all right for you. You are not bothered about Supreme Court independence or basic structure or something like that. So I think the role of private power is an unexamined aspect of the Supreme Court today. And these lawyers representing those private powers hold great influence, and as a matter of fact, today hold greater influence on the Supreme Court than ever before. So I don't know which way we are going to end up, very frankly. There's this private power. You are dependent on private power. You are dependent on government. You are dependent on public institutions. The poor citizen is lost. Where does he get a fair deal? He doesn't get a fair deal anywhere. He doesn't know. And you can see in the current COVID crisis, you go to the hospital, no oxygen. You go to the hospital, no bed. You go to the hospital, no drug. You go to the hospital, no doctor. You go to the hospital, no attendant. no sanitization. Who is responsible? Is anybody willing to take the responsibility? Is the Supreme Court's are its eyes shut to what the people are undergoing? And what kind of basic structure am I to glorify and put the basic structure on a pedestal and worship it every morning? For what? If ultimately it's going to result in my death through this, again I come back to Professor Roznai, the incremental erosion, steady but very firm erosion by a set of people who, despite their different political badges or political names of different political parties, have a common agenda. And the common agenda is corruption. The common agenda in India is corruption. Political parties talk about common minimum program. What is the common minimum program? After directive principles and fundamental rights, do you need any common minimum program? As far as law is concerned, the common minimum program is corruption. And over the years, again, if you'll see, the Industries Development Act, which is a central act, in the public interest under the Constitution, the center can push any industry from a state and declare it to be part of the central control. And this is what has been happening. As politicians see in every state, oh, this industry is a cash-rich cow. You'll get a lot of money from this industry. Immediately demands start from the center. Oh, put this industry under the Industries Development Regulation Act because it is an industry vital to the public. So therefore, it comes into the den of the center and the central politicians. There's so much happening, to leave the basic structure as a hollow thing, as a beautiful phrase, because once you take the money out of it, there's nothing left really. So please, I think again, Ashit and Jagtap and Vandana, thanks to all of you. We have been able to get together and discuss these thoughts.
So we have been enlightened by you, sir. The amount of knowledge you have regarding the inside of the Supreme Court is unparalleled. And this has deviated us from the whole topic of basic structure. I think we have grown a little less able to the idea itself.
Just for your information, Yogesh was part of it. We held a confidential, very closed door confidential meeting at NLUO. Yogesh, yaad hai? Regarding the functioning of the bar in the Supreme Court.
Yes, sir. Yes, sir.
And I insisted that this be closed door and confidential, because otherwise I'll be for a couple of years inside the cooler, in the jail. And I wrote it down. And I still remember the Vice Chancellor Faizan, he says, "Arey yaar, tumne likh bhi diya, you have written it also." So maine kaha, haan, I've written it so that the memory doesn't fade away. That's all.
That was an eye opener, sir.
So you can borrow it from him and just read it.
Surely, sir. Yes. Due to paucity of time, we'll stick to this last question to Yaniv, sir.
Yes.
Then we can end the session.
So it is really a concern of time. Otherwise, we would love to hear about, sir, what you are telling to us.
Thank you very much. I hope you can hear me well, because it says that my internet connection is not that good, but I'll try to answer. It's a great question about the alternatives to the doctrine. And I want to say two things here. The first one, the most obvious and primary alternative for the doctrine is constitutional design. If you get a relatively more rigid amendment procedure that is inclusive of the people, deliberative, time-consuming, that makes sure that the change really reflects the deeper will of the people and not just the majoritarian caprice of the political majority, this moment political majority, then this, I think, is a suitable alternative. And one can have perhaps even a better design which is what Richard Albert calls a second order unamendability, which is escalating design, something similar to what Indian already has, but an improved one that really protects the core elements of the Constitution through a very rigid procedure, and vice versa, still allow progress and advancement by more flexible provisions. So it is interesting to see that the doctrine, the basic structure doctrine, has emerged where in all countries where you don't have an extreme rigid amending procedure. So this, I think, is the obvious alternative. The second alternative I want to suggest is still in the realm of the judiciary, not outside, not in constitutional design. And here we can think of two ideas. The first one is that invalidation of amendments that infringe upon the basic structure would require a supermajority of an extended bench of the judges. Think of 6 out of 9. Because a decision of 5 versus 4 that a certain amendment violates the basic principles, to my mind, is not convincing at all.
Yeah.
If you have 4 judges, in addition to the politicians, that think that the amendment is fine, it's not very convincing. So this is one thing I would consider. Alternative is something similar to the British Declaration of Incompatibility, that the court would simply declare an amendment to be incompatible with the basic structure, but will not invalidate it, but simply return the ball back to the politicians, which now have the pressure of the court and of the media on them, and they need to consider whether they want to change the amendment or not. When there's a judgment of the court saying this amendment violates the basic principles of the Constitution, but we cannot invalidate it. So these are two judicial alternatives I would consider.
A referendum? Professor Roznai, a referendum? Provision for
a referendum. I hesitate about a referendum. I'm happy about referendums if they are part of the amending procedure. So you have the politicians adopting something and then bring it to the people. Just asking the people one time, I don't think it's satisfied. Look at Brexit, a decision of 51% versus 49. Does this really reflect the deep will of the people? I don't think so.
That's true.
Thank you, sir. Thank you, Roznai, sir, for your answer. Deep insight. Sir, I just want to take one more question, sir, because it's already time, and sir, I think it's important question. So, sir, we have in the chat box, sir, how to strike a balance between the judiciary and the executive to ensure that no one pillar become powerful over the other. What are the solutions to strike this balance?
Was this question referred to me? Because I only heard the last 2 words. Can you repeat it, please, if it's for me?
Sir, it is to Krishna, sir, or Yogesh, sir, whoever wants.
Perfect. Good.
Look, the judiciary can never match the executive. It's that simple in terms of resources, in terms of information. And as a matter of fact, when Yogesh and I were in the Supreme Court, heading their research unit, the first research unit of the Supreme Court for the judges, we had, floated a proposal that the Supreme Court must make up its mind what it wants to do. If it wants to enter into every single issue of governance, small, large, constitutional, legal, then it must have the necessary information. Then it must set up virtually a parallel number of ministries within the Supreme Court so that each ministry can be kept under check. And if you don't want to do it, then please don't try to monitor in bits and pieces every single executive action. How many times, the ritual should be there in a religious practice? How many times what should be the ticket for entry to the Taj Mahal? What should be, you have the judiciary today spread over everything. There is no area which they say is exempt from our scrutiny. You can't function like that. So the judiciary has to limit, but then it's a question of the sense of power. Again, you see, I must link it up to something more. If there are, of course, if there are judges who are looking constantly to appointments beyond retirement, then you're going to have these judges using this kind of scrutiny as a bargaining counter with the executive. And this has been going on. So therefore, for example, why should the chairman of the Consumer Commission, National Consumer Commission, while he's yet to retire, say about a month later, be already carrying a letter in his pocket that he is the chairman of the National Consumer Commission? So obviously there's something wrong, no? And like that, you can multiply the examples. I mean, we have had even judges who have resigned from the Supreme Court at midnight to be able to stand for election the next morning, national election, and Justice Behrul Islam from Assam. So it all depends, on, as I said, the judges, the structure is, as Yogesh pointed out, and then Professor Roznai also indicated, unaccountability, complete, total, absolute unaccountability of the judges. Now, you can't have unlimited power of this kind and then decry the unlimited power of the executive. In India, we have coined a word called constitutional morality. This is not constitutional morality. This is constitutional asymmetry. So judges want A facility. Judges want B facility. Judges want C facility. They write to the government. They want to go abroad, for which they are not entitled under the rules. So they write to the minister concerned and they get the permission. Now this judicial behavior does not come under public scrutiny. And you don't have the media really getting into this, because media also there are media houses and there is a whole architecture there. So therefore, the Supreme Court really has to make up its mind between the span of judicial scrutiny it wants and where it would draw the line that it will not examine these issues. It will not examine these issues. At least it will be clarity to the litigants that, look, I should not go to the Supreme Court for this. Because what is the point of giving the right to education and declaring it as a fundamental right when the hundreds of petitioners from all over the country had come to the Supreme Court, and then after that, after a few months, they come back to the Supreme Court and say, look, this is not being implemented at all. Where do we go? We are seeking contempt. And what does the Supreme Court tell them? Oh, don't come here. Go back to your respective high courts. So what's the point? You go back to your respective high courts. High courts will either sleep on it, do nothing, or may give you an adverse judgment. Then you again come back to the Supreme Court. Now, NGOs, even well-meaning NGOs, don't have that kind of economic and physical strength to do a runaround of the courts. They can't. And India is a vast country. They can't run around the whole country trying to get this judgment enforced. So ultimately it comes down to the nature of constitutional governance in India. The nature of constitutional governance, which will include the span of governance, the kind of people being put in place for governance, the scrutiny of the people who are being governed, and what are the cross checks on those who are misusing the power to govern, whether it's judicial or whether it's executive.
Yes, on that note, I think we can bring the session to an end. Thank you so much, Yaniv sir, Yogesh sir, and Mahajan sir for taking out time and enlightening us with all the great inside story which we do not know about completely.
Nice.
I think Shraddha can take over. Shraddha?
Mic is off, I think.
Shraddha, we can't hear you.
She
You're
has
not
to
audible.
unmute herself or something.
So she is unmute, I guess.
Oh.
Okay.
Hello.
I'll yeah, you're audible now. Yes.
Yeah. Oh, she's disappeared.
Right. I think I'll
Ashif, you can do the
yes,
formality.
yes. Sure, sir. No, sir. So I'm really thankful to all the respected panelists from the side of Center for Constitutional Law, along with Dharmashastra National Law University, for taking out time and enlightening us with all this great knowledge. Thank you to Krishna Mahajan, sir, for telling us the inside out of Supreme Court of India. Thank you to Yogesh Pratap Singh, sir, for telling us the history as well as the technicalities of how the judges are seeing the idea itself. And thank you to Yaniv, sir, for telling us the international perspective. On that note, we can end this session. And thank you so much for everyone for joining us today. Thank you.
Thank you, Ashit.
Thank you. God bless you
Thank
all.
you, sir.
Thank you very much.
Thank you,
See you in
Yogesh.
2 years when we celebrate 50 years.
Oh, yes.
Thank you, sir.